I'm trying to see how.
So here's count 1, not guilty, guilty.
Wow.
Count 2, not guilty of the offense or any lesser included. Some would say objection, compound question, right? Objection, compound question. But then you have guilty of the offense as charged, manslaughter while operating motor vehicle, guilty of the lesser included, involuntary manslaughter, guilty of lesser included, motor vehicle homicide, guilty of the lesser included offense, operating under the influence. Much more confusing, but sometimes it could feel like if you think it's not guilty, then you still feel like this looks like every other one, right? 1 and 2, 1 and 2, 1 and 2. So if I think she's not guilty of this manslaughter, am I then going to go down and look at these 3? What do I do with these 3? Now, it very clearly says, or any lesser included, which I understand. I just don't know why we wouldn't want it to be clearer.
I don't understand.
I think that this is going to pass muster on appeal. I do not think they're going to win for this appellate issue.
Wow, they upheld this?
And it's kind of cheating because we know they already didn't win on this, but not guilty of the offense charge or any lesser included is probably good enough.
Right.
But it's not the best answer. And in law school, with so many of the tests we take and exams and even the LSAT, it's not always the right answer because there can be multiple right answers. You're supposed to pick the best answer.
Mm-hmm.
And so to me, I agree that the defense's option is the best answer, but I do not think this is a situation where it's going to be something that's overturned on appeal. At least that's the way I see it personally. Okay. So now let's get to, we kind of already know the answer to this, but I thought it would be interesting.
What?
Oh shoot, did I just lose it? Here it is. I am going to bring up now this little interview that was done with Karen Reed earlier today regarding this motion that was filed by the defense. Let's hear what she had to say about it.